Hey everyone, in today's episode, I'll give you the rundown on the 2025 United States Supreme Court decisions that matter most to employers. We're talking religious accommodations, political speech at work, and more. Hello, welcome to Workplace Wake Up. I'm Jen Shaw. Every week, I spend about 15 minutes covering key legal developments, introducing you to interesting guests, and providing some entertainment to start your workday. I hope you enjoyed this week's episode. Oh my gosh, our topic today is one of my most favorite topics. I am fascinated by the United States Supreme Court. I always have been, even when I was a kid. I, believe it or not, have never been to watch them in action, which is very disappointing to me, but I will do that. That is definitely a bucket list item. I wanted to do it when Justice Ginsburg was there, and I didn't do it, and I really wish I had. The United States Supreme Court has come under a lot of fire recently, and I'm not going to have a political podcast here, so don't worry about that. There are lots of things going on with the court that I don't like. There are ethics violations, at least there appear to be. There's all sorts of things going on that seem not appropriate for the highest court in our country. Having said that, they issue very important decisions, several each term, that are employment law based. And during this term, during the 24-25 term, there have been a number of important Supreme Court decisions. And I want to go through them with you today so you understand a little bit more about how the court decisions can impact you if you do business in the United States. Now, if you do business somewhere else in another country, this may not be as relevant for you, but it will help you think of why you need to be careful in following your own court decisions, right? Just because they're coming from a court far away from you potentially, right? So in California, we are going to be subject to what the United States Supreme Court holds in Washington, D.C. That doesn't mean they don't apply to you, okay? Many federal laws in the United States apply to everyone. Now, if you're in a state that has a law that is more strict than the federal law, then your state law is going to apply. Okay, because the federal law is oftentimes a minimum, but not always. Think about the Pregnant Workers Fairness Act, right? That's a federal law that is actually more strict than any other state in terms of pregnancy accommodations. Okay, so here are the cases. Let's go through these cases step by step. There are really two of them that I want to highlight for you. Remember, the court hears cases on lots of different issues. And at this point, it have issued two very important decisions on employment law. One is Ames versus Ohio Department of Youth Services. Now, in this case, the court was trying to determine if somebody is making a discrimination claim and they're part of a majority group. So in our country, at least currently, that would be considered Caucasian. If they're part of a majority group, does the same standard of proof apply under Title VII of the Civil Rights Act? Or do they have a heightened evidentiary standard because they're a majority group? In other words, do they have to show more because they're claiming reverse discrimination? Okay? And the court said in a unanimous decision, which is pretty unusual for this particular court, they said no. The standard of proof is going to be exactly the same whether the person suing is part of a majority group or a minority group, okay? So that means when you're thinking about documentation and you're thinking about how you're making decisions, you want to be very careful that you are treating everybody fairly. Nobody has a higher standard because they're a member of a, quote, majority group. Okay, so that was a very important case. Again, it's Ames versus Ohio Department of Youth Services, AMES. All you have to do is Google and you'll find a bunch of information about it. The second case is EMD Sales versus Carrera, okay? This case, EMD Sales versus Carrera, C-A-R-R-E-R-A, this case is about correctly classifying employees under the Fair Labor Standards Act, which applies to every state in the country, okay? By classification, we mean, are they exempt or are they non-exempt? Remember that exempt employees are not entitled to be paid overtime. They don't have to take rest breaks and meal periods. They don't have to record all of their hours worked. Okay? If they are non-exempt, they must be paid at least minimum wage, the applicable minimum wage, which may be different depending on their state or their municipality, the location where they're doing work. They have to be paid at least minimum wage, and they have to record all their hours worked, and they have to take meal periods and rest breaks as required by applicable law. And California is not the only law that has very strict meal and rest break rules, okay? There are many other states. So in this case, the court said, look, one of the exemptions is the outside sales exemption, okay? And what the court was saying here is there are a number of requirements that you have to meet to qualify for the outside sales exemption. And the outside sales exemption requires you to be 18 years of age or older, spend at least 50% of your time or your primary time at work in the field selling, and that you have some discretion and independent judgment. Okay? Those are the main things. And really the first two are the most critical ones. Are you 18 years of age or older? Because they don't want kids to be taken advantage of here. And are you in the field at least half of your time or for the majority of your time selling? Now, selling could be taking orders, but selling isn't schmoozing with clients to try to get them to buy your product, right? It's actually selling. So the outside sales exemption is really for people who are selling a product and they're going out in the field to sell the product, okay? So that is what we're talking about in the EMD sales case. The reason it's important is it goes through a lot of analysis about the status of exempt and non-exempt employees and how you make that determination. And I want you to remember that employees are presumed to be non-exempt, okay? They're presumed to be not exempt from the labor and employment laws that are contained within the Fair Labor Standards Act and contained within the applicable law of a state. Now, remember, some states don't have their own wage hour laws. They just apply the FLSA, the Fair Labor Standards Act. And then other states have their own sort of set of statutes where they may impose higher requirements or more strict requirements on the employer. Okay? Now, what I want you to think about when we're talking about these wage hour issues and the cases that have been issued by the Supreme Court, I want you to also think about how they apply to you, okay? And sometimes there's going to be an entrance requirement because remember, these are federal laws. So sometimes you have to meet a certain threshold of business in terms of your revenue. You have to be engaged in interstate commerce. So it's going to be important to figure out how these decisions apply to you, but you need to know that they exist. Another decision that just came down is Stanley, Stanley versus the city of Sanford, Florida. Okay, in this case, the court was determining whether an individual who is no longer employed by a company can still sue under the ADA, the Americans with Disabilities Act, for disability discrimination. In this particular case, the issue was the allocation of post-employment benefits. So in this situation, the employee worked for a city. They had been providing free health care to firefighters who left the force due to disability. 4 years after she retired, the policy changed, and then she no longer had free health care access. She sued under the ADA, saying she was being discriminated against, and the majority of the court rejected her claim, saying no, this rule applied to everybody. You weren't being picked on just because you had a disability. This was part of a decision that the employer made to reduce their costs and to allocate benefits in a different way. Okay, so that's an important case. The other things I want you to think about that the Supreme Court has not yet ruled on, at least not definitively, are many of the executive orders that President Trump issued in the first couple of months of his administration, okay? And it's very important to remember that all of the cases that have gone up to the court so far have been there on procedural issues. Now, there may have also been substantive issues involved, but they have been decided on procedural issues. What that means is the court sort of skirted the substantive issue to get rid of the case on a procedural ground, okay? Because these justices do not agree, okay? It's very rare, as I said earlier, to get a unanimous decision from this court. So there will be more coming in the next term on these cases about the executive orders, DEI, the firing of the federal employees, all of those issues will be coming. The other thing that we are likely to see from the court in the next term are decisions relating to agency interpretations. Remember that last year, in last year's term, the court decided the Loper-Bright versus Raimundo case, in which they rejected what's called the Chevron doctrine. So for like 40 years, the court was very focused on deferring to agency interpretations. If there was a vague federal law and the Equal Employment Opportunity Commission or the Department of Labor or OSHA or the EEOC interpreted that vague rule, that vague law, the court deferred to that. They said, yeah, we think the agency is probably in the best place to be able to understand what Congress intended. So we're going to go with their interpretation unless we think something is radically off. Well, this court threw out 40 plus years of precedent and the Chevron decision in the Loper-Bright case and said, we're not deferring to anybody. If there's a vague statute, then Congress has to fix that statute. We're not going to presume that an agency interpretation is a valid interpretation of what's going on. Okay? So there's a lot going on here with this Supreme Court. It's very important to know what's going on with the court. I don't know if President Trump will get any additional appointments in his term. It's very likely that he will at least get one or two. We don't know. There has been talk that Clarence Thomas will step down. I don't think that is going to happen, but it could. So keep your eyes open. I remember a couple presidential elections ago, somebody said to me, you know, it doesn't matter who you elect for president. It's all the same. I said, oh no. The thing you need to think about always is who they get to appoint to the court. Because remember, these United States Supreme Court justices, just like every federal judge in the country, they are appointed for life. So when you appoint somebody like Amy Coney Barrett, for example, who's very young, she could be on the court for 30 years or more. And that may be good news for you, or that may be bad news for you. It depends on where you fall in terms of her views. But what is really important to understand is that court has a lot of power. Now, whether they will exercise it to rein in the executive authority, which is what's going to be before them in the next term, we will see. But for now, keep your eyes and ears open. Really take some time to pay attention to what's going on. I think sometimes it's overwhelming to be on the internet with all of these sources and all of these companies that are providing guidance and providing analysis of what's going on. Find a couple of law firms you like and follow their stuff. You're going to mostly get what you need. Okay? And it's good to pick big firms, because big firms like Fisher Phillips, like Proskauer Rose, like Jackson Lewis, like Littler Mendelsohn, they have teams of lawyers. All they do is issue blog posts on new laws, okay, and new court decisions. We do that as well. We're a small firm, right? So we try to keep up, but we're not going to be able to keep up as much as a large firm would be when they have a dedicated core group of lawyers when that's all they do. So be smart about where you get your information. Educate yourself. Stay on top of things. It's interesting. It's fun. It will make you better at your job. Thank you so much for joining me today, everybody. Go have an ice cream or something yummy and enjoy the rest of your day. Workplace Wake Up, including our guests and hosts, do not provide legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction. If you enjoyed this episode and would like to spread the word, please share it with others. Post about it on social media and/or rate and review it. You can also follow us on LinkedIn, Twitter, and Facebook, and email us at info@shawlawgroup.com.